The Supreme Court just released an 8-1 decision on gay conversion therapy. I had thoughts about this, but there's a distinction in the opinion that I think a lot of people are going to miss. My name is Michael Campbell. I am a licensed master social worker and I'm a therapist, and this is how it affects you. This was brought to my attention by watching a video from Brian Tyler Cohen and Mark Elias. I thought it was a really interesting video, so I'm going to put the link down below so you can watch that video as well. The case was brought to court by a licensed professional counselor named Chiles of Colorado. The case is called Chiles versus Salazar. She was backed up by the Alliance for Defending Freedom, which is a conservative legal organization. It becomes interesting because Chiles said that she has never practiced conversion therapy. Her concern was based on principle. Therapists should not be forbidden to practice what is necessary for their clients. She says that she uses talk therapy and explores the client's feelings about their identity and sexuality. Colorado actually argued in court that the way Chiles practices is probably not against the law. But nonetheless, this went all the way up to the Supreme Court. Additionally, the court said this law allows a therapist to affirm a client's sexual orientation and gender identity, but the law does not allow them to challenge or question that. And that is, according to Justice Gorsuch, who wrote the majority opinion, viewpoint discrimination. When the government tells you you can have this viewpoint but not another viewpoint, that is against the First Amendment, and therefore it is unconstitutional. So the Supreme Court then sent the ruling back down to the appellate courts. What this means is that any laws that are written in such a way that match Colorado's will likely be determined to be unconstitutional, and this affects about 30 different states. So here's the thing that I kept coming back to as I was reading this. The ruling is mostly about speech. The ruling is not about conversion therapy itself. The Supreme Court did not say that conversion therapy is safe. The Supreme Court did not say that conversion therapy works. They did not endorse it. What they said is that the government cannot write a law that tells a therapist that you can talk about this topic from this angle, but not from a different angle. Now, I'll be honest with you, as a therapist, I had to sit with that for a second, and I agree. I don't want the government to tell me how I can talk to my clients using a certain framework that could get flipped around and used to restrict the affirming and evidence-based care that I provide every day. So speech protection, yeah, it actually helps. Conversion therapy as a practice is harmful. That's just not my opinion. That's what the evidence and the research demonstrates. Every major medical and mental health organization has come out against conversion therapy. We're talking about the American Medical Association, the American Psychiatric Association, the National Association of Social Workers, which is the board that I belong to, the American Pediatric Association. The evidence is incredibly clear. Out of 302 scholarly articles, 300 of those articles indicated that the therapy was actually harmful, increasing depression, and increased rates of suicidality. We need to be able to understand that two things can be true at the same time in this case. Conversion therapy is dangerous and harmful, and that speech needs to be protected. So what does this actually mean going forward? I've been thinking about this, and this is where I'm landing. Your therapist's ethical obligations, those haven't changed. Licensing boards still exist. The National Association of Social Workers has a code of ethics that I have to follow by having a license. That says conversion therapy should not be practiced. That means that therapists can still face board complaints and board discipline. The ruling struck down the state law. It did not change professional standards. But what has changed and this is important, is that there's one less layer of protection for the children and the kids that we treat. So those state laws, those are a backstop, especially for kids. And this is the part that I think is worth sitting with. Children cannot file their own board complaints. A lot of the time it's the parents who are seeking out the conversion therapy in the first place. So without this law, enforcement depends more on the licensing board, and the process is slower and harder to get to. And who is going to know that conversion therapy is not an evidence-based practice? And onus is on the boards to try and figure out a way to prevent this from happening. The other thing that I find really curious is, where does this go next? The logic just does not apply to conversion therapy. It could apply to any situation where a state tries to restrict what a licensed professional can say to their clients. Justice Jackson is the one who dissented, and this was her exact point. Her point is that this could open up a path where licensed professionals can claim a constitutional right to practice below standards of care. For everyone, I think what is most helpful to keep in mind is what the ruling actually said and what it did not say. The conversation around this is going to be loud. The more we understand the distinction between the speech question and the practice question, the better the conversation will be. That's how this affects you. If it helped, save it for later. Share it with a friend who could use it, and follow along for more breakdowns just like this one. I'm Michael Campbell. Thanks for watching.